Hello everyone, you're welcome to another episode of Talking Legal with CCA. My name is Olaomi Ojo, the Senior Associate at Trusted Advisors, and I have today with me Emmanuel Oguntimehin, the Head of Practice at Trusted Advisors, and a member of the Dispute and Management Resolution Team. Today, we'll be leading discussions on the benefits of arbitration for resolving cross-border commercial disputes. So, Mr. Manuel, it's a pleasure to have you on the show.
Thank you, Olaomi. It's a pleasure to be here.
Thank you so much. I'm looking forward to the discussions we're going to have today on arbitration as it regards cross-border commercial disputes.
Same here.
Okay, so to start with, I'm curious to know, can you briefly explain what arbitration is and how it differs from traditional litigation?
Okay, thank you, Olaomi. Arbitration is one of the alternate dispute resolution mechanisms by which parties resolve their dispute. It takes the form of parties by agreement allowing or adopting a third party, usually called an arbitrator, to superintend and adjudicate upon their dispute. And the way I would say there are different instances where you can say that arbitration differs from conventional litigation. But chief amongst that is the fact that for core litigation, it is compulsory that parties attend court proceedings. But for the arbitration, one of the parties or a party cannot compel the appearance of the other party. So that's the major difference.
Well, that's fantastic. So in all of this, are there any distinct or major advantages that arbitration, has as a dispute resolution mechanism, as it refer to international business conflicts?
Yes, there are myriads of advantages actually that arbitration has. I'll start with the fact that it yields a faster resolution turnaround time as opposed to conventional litigation. Here, you know that parties are able to at least schedule the sessions with the help of the arbitrator that has already been appointed. So the typical bureaucracy, or I would say the typical issues that normally would bog down maybe procedures that will bog down litigation or that will happen in litigation does not really apply to arbitration. Second is the issue of finality of the decision of the panel. So the decision of the panel when it comes to arbitration is called an award. The award, the way it is, it's binding usually on parties. So there's a form of finality, maybe say for in maybe special or some maybe exceptional situations where it will not be binding, but generally parties understand that the award being granted by the arbitration panel or the arbitrator is binding and final on parties. If you look at it vis-a-vis the conventional litigation, that's not the situation. Typical litigation or conventional litigation will usually attract maybe appeals, and it can go on and on and on for years. So the issue of finality is one of the major advantages that arbitration has over conventional litigation. Also is the issue of equality of parties. So the way this plays out is at the regime of arbitration usually dictates that both parties are placed on same equal footing. So this might sound very technical in nature, but you realize that it goes as far as even to the minute, to the second that is applicable to maybe a party. Same must be accorded for another party, so that we don't have a situation where one party is crying foul on why he was not given the same opportunity as the other party. Also is the issue of confidentiality. Litigation is public in nature. If you look at it, it's subject to its open third parties by being in court, and the information that will be peddled or that will be shared in court might be something so important, and so it might go to the root of the operations of a company. And if that is said in open court, Of course, the press, and even maybe third parties that ordinarily shouldn't even be aware of such, maybe trade secrets, business mode of operations, will actually come into knowledge of that. Arbitration, on the other hand, is private in nature. So that enables and encourages parties to deal more or to robustly engage on that. So the few advantages.
Well, good. While you were speaking, I picked something quite interesting. One of the benefits that arbitration has in cross-border disputes over the other means of dispute resolution, you mentioned the fact that it's the faster turnaround for resolution.
Yeah.
Now, I'm sure that a lot of one of the major challenges that we have in the legal system, as peculiar to Nigeria or in some other parts of the country, is the fact that resolutions, especially litigation, can take a long time before you get, some level of closure to it. So I'm curious to know, and I would like you to, not just for the purpose of this discussion, for the viewers that are, watching us, if you could kindly elaborate on the time-saving aspects, and the importance of this time-saving resolution that arbitration offers in cross-border disputes.
Okay, thank you, allow me. So I will want to start with to talk about the flexibility in the scheduling that arbitration offers. So because arbitration itself is not bogged down by the strict rule with regards to maybe evidence, maybe procedure and all that. So it affords parties an opportunity to choose the day, the timing, even the legal regime that they want to apply to, or even the forum that they want to apply to their dispute resolution. So the typical instances or the typical issues that will ordinarily bog down litigation if you are having cross-border maybe transactions and maybe there's a dispute stemming out of that. Issues such as maybe all public holidays, the timing, where if someone is in Nigeria, the other party is somewhere, let's say somewhere in Asia. The timing, of course, it's so much. The morning in Nigeria might be in the evening. So all that arbitration offers parties that opportunity to be able to pick a time that is convenient to all parties. So that speaks to the issue of the flexibility that it brings about. Also is the fact that it offers an opportunity for experts to take over and superintend over the dispute resolution talks or sessions. So arbitrators themselves are experts in their own respective fields. And so it's akin to you getting round pegs to fit round holes. So unlike if you look at litigation, for example, there are instances where you might feel or you might know that probably maybe the judge that is handling the matter is not probably maybe ceased, of maybe there was not it's like just ceased with knowledge in respect of maybe that aspect of practice. So having to go back to maybe conduct, maybe to carry out maybe further research and all that, that will not ordinarily happen in litigation, in arbitration, because you have experts, so they can immediately get on the job and be able to speak to it because they are known and they are used to that particular field of practice. So also is the issue of finality, just like I had mentioned earlier. Unlike the core litigation, where the decisions of the court is susceptible to appeals, and it's one of the rights that the other party has, or maybe the party who loses in court has. So you can approach the appellate court to maybe to further take its matter and see whether it can, maybe the appellate court will bend backwards or maybe see its own facts from the way he's portraying it. But for arbitration, it's different. Arbitration, because you understand that the decision itself is binding, so it's only on limited instances that the award that is being granted or that's being awarded by the panel will not, maybe that result will not be binding on the disputant. Also, I would like to speak to the issue of confidentiality also. Confidentiality, yes, like I said earlier, litigation is public in nature. Arbitration offers privacy to disputants. So you look at if you have disputants who cut across maybe respective zones, maybe different countries and all that, they will feel more comfortable and be able to deal more when they know that the information that they are putting out there is private to those that are actually within the room where arbitration is going on, and as opposed to it being susceptible to maybe members of the public or even the members of the press.
Okay, so how does this relate to the time-saving um, benefit that arbitration has?
So
the confidentiality.
The confidentiality. Yeah. So because parties are opened and they know that this offers them privacy, so are willing to come to court on time. So long as you have time or sessions scheduled, they are able to engage. They know that whatever discussion or whatever information they are putting out there, whatever data that they are offering in respect of maybe during the course of the proceedings, they know that it's private, it's protected, they can protect their trade secrets, their mode of operations, and all that that can come up. So because they can deal and engage day on day, it affords them a faster opportunity to resolve their dispute as opposed to typical litigation that can go for a long time.
Okay. Yeah. So we've spoken, quite a lot on the benefits that arbitration has as regards to cross-border commercial disputes. However, are there particular industries or specific types of cross-border disputes that arbitration is more suited for?
Thank you, allow me for the question. Yes, there are different industries that arbitration can be leveraged upon. We talk about maybe the banking and non-banking. We talk about insurance. We talk about commercial transactions, contract reviews, and all that. So arbitration, even from the body language of the court nowadays, you realize that even the rules of the court are structured to encourage that for parties to, at least rather than stick in court, find a way to resolve their matters outside the courtroom.
Fantastic. So you've spoken extensively on the benefits of arbitration. You've spoken on how it offers a faster resolution time as compared to litigation. You've also spoken about the different kinds of industries that arbitration is more suited for. So for those people who are players in this industry or intending players, how can businesses and legal professionals stay updated to the latest developments or trends and best practices for arbitration in commercial cross-border disputes?
Thank you. So I would like to advise, at least for maybe professionals, legal professionals, specialists in this field, to maybe attend webinars, seminars, you have workshops, you have trainings, and also to join arbitration groups. That will actually help them to stay in front of issues, at least pertaining to cross-border commercial disputes.
Great. Thank you so much, Mr. Emmanuel.
Thank you.
As we wrap up the session for today, it's been a wonderful time sharing this educating insights with us. It's been lovely having you here. Thank you so much. Thank you to everyone for today. We have finally come to the end of another episode of Talking Legal with TTA. To stay updated on trends and insights from the trusted advisors, kindly follow us on our website at www.trustedadvisorslaw.com and all of our social media platforms. We hope to see you some other time. Bye.